I'm often asked whether, in addition to the normal periodic child support payable between parents as assessed by the Child Support Agency, whether a non-custodial parent can be forced to contribute to private school fees. And these private school fees can be expensive. A top private school in Australia with boarding fees is going to cost a parent somewhere around $100,000 per annum. Even moderately priced schools can put a considerable burden on a family budget. The answer to the question is yes. A non-custodial parent can be forced to contribute payment toward a child's private school fees. That comes to us via section 117(2)(a)(2) of the Child Support Assessment Act of 1989. It's where the law is stated. But as is often the case with these situations, the statutory statement of the law is not particularly clear. To get a good understanding of how the law actually operates in practice, the decisions that the courts have handed down on the section from time to time have to be looked at and read and understood. The leading case on point is a case called Me and Ferguson from 1986. It's reported in the 1986 volume of the Australian Family Law Cases. Now, I can see the more astute of my viewers are thinking, well, what is going on here? We have a 1989 Act being interpreted by a 1986 case. Well, Me and Ferguson is considered such good law that the courts have continued to use the principles enunciated in it, even in Stage 2 cases, which are cases which interpret the 1989 Act. So even though it's a 1986 Act, it's still very good law. For those with access to a law library, you will find the applicable section of the case is at page 75,191 of the 1986 report. And essentially, Me and Ferguson makes 3 points. Point 1, even if a man, and it's normally the man who is being asked to contribute to the school fees in this way, even if a man is wealthy and can afford private school fees, he can't be compelled to pay just because he is wealthy. Point 2, if a parent has previously agreed to pay the school fees and send the child to a private school, that parent can be compelled to pay the fees, subject to their capacity to pay. Point 3, even if there's no agreement between the parents, if the child has a particular special need, say the child is very musical and the proposal is to send the child to a private school with a good musical program, the parent can be compelled to pay even though there's been no agreement. Subject, of course, also to the parent's capacity to pay at that point. It needs to be remembered these decisions about private schools are often made when the parents are together and there is 1 or 2 incomes coming in to support one household. And later on, after separation, that same income now has to support 2 households. So the courts are very mindful of that. My name is Simon Bacon. I was a child support lawyer for 35 years. And if you have any further questions or queries regarding private school fees, have a look at my website, childsupportlawyers.com.au.